Shea Pro Concho with Anna DeBlantis. Up for another day of broadcast insolence right here. And let us get started with the update of the Jason Van Dyke trial, which now is well into its second week at the Criminal Courts Building, the Layton Criminal Courts Building at 26th of California here in Chicago. We have Eric Rung, who was in the courtroom all day, and our legal analyst Mike Monaco joining us. And let's start with you, Eric, and let's talk about what the highlights of today's testimony were. It's about 5 hours of total testimony. A number, about 4 or 5 witnesses?
Seven witnesses.
Seven witnesses
today. A couple of them overlapped. A couple of them were the ones that were working in the juvenile detention center when Laquan McDonald didn't want to go back into a cell. The testimony we had already heard before from a couple of other officers. But kind of the highlights, I would say, today was we also heard from another officer who was on the scene that night. Her name was Leticia Valez, and she pulled up. She got there after the shots had been fired, but had seen McDonald walking down the street. Said that in her mind, she thought that when he reached toward his hip that he may have a gun, and she definitely thought that he was a threat. Now, a couple interesting things that the prosecution brought up on cross-examination there was that one, she had argued with her partner whether or not they weren't even going to go to the call or not. Their call came out for help.
She argued with her partner in the car on the way to the call.
Right. That she wanted to go to dinner instead of go to the call. So the prosecution said, well, you thought that this was so important that you wanted to go to dinner rather than go to this call. The other thing that she said was that Officer Van Dyke's partner that night, Officer Walsh, as soon as he kicked the knife away from Laquan McDonald, that he immediately searched him for other weapons. Of course, if you watch the video, that does not happen, and she couldn't account for. She just said, I know he did it. But it's clearly not on the video there as well. The other thing that was really interesting was we heard from the man who made the first 911 call about Laquan McDonald that night. His name was Rudy Bareilles. He's a truck driver. He pulled into this lot. He says that he saw an African-American in one of the trucks. He told him to get out 2 or 3 times. He said, if you don't get out, I'm going to call police. He then called 911. We've heard the 911 tape where he says, there's a man stealing radios. And then he has a confrontation with McDonald before police get there. He says that McDonald lunged at him once, and when he did that, he threw his phone at him. Yeah, with the knife. He was about 3 feet away from him. He threw his phone at him, and then he says McDonald lunged at him once more with the knife, never hit him or anything. And then at that point, he had reached down, grabbed some gravel, and threw it in his face. And by that time, you could hear some lights and sirens, and Laquan McDonald took off. The defense is playing this up as this violent man that was out causing all this problems throughout the city, and he had a physical altercation with this man. And so the prosecution came back up on cross-examination and said, so you're telling me that you fought off this teen with your cell phone and a handful of gravel? That's all you needed to be safe from this man, basically, is what they were saying. I'm paraphrasing. And he said yes.
Well, right, but also there was testimony that they'd heard the siren, that the sirens were approaching.
I mentioned that. Yeah.
That was probably.
Yeah.
I mean, I get what the prosecution was trying to do there in cross-examination, but is that effective?
It shows you that they're not used to cross-examining prosecutors, because the defense ordinarily does not call many witnesses, because asking this victim, Bareilles was a victim, asking him, saying, well, he didn't really touch you with the knife, did he? Well, he lunged at me with the knife. Right. It wasn't because ask
Bareilles if he had a gun, what he would have done.
Exactly.
Right? I mean, that's a separate issue.
That is, I thought, such a poor decision by the prosecutor to ask him questions allegedly to minimize his testimony. His testimony is what it is. I mean, you could say, Van Dyke didn't see that. That would be evidence. Yeah. But to say that he didn't actually stab you with the knife, he didn't touch you with the knife. Well, no, but that's not because He didn't try. He lunged at me with it.
Right, and Burles doesn't have a badge either and isn't responsible for the bodily harm that Laquan might do to somebody else as he walks down to the street. And I know that a big part of court today was use of force and whether or not there was justification for use of force. And they went through the things that not all of us know, but that the police experts do know in training about when you use it.
Right. The defense called the Chicago Police Department's attorney, the one that is responsible for doing the training of cadets at the academy. And so she went through basically Illinois law on when police officers can use deadly force. And so she went through, there was 4 of them that they went through, and all of them started with reasonable and necessary in order to stop someone. Either they could be from causing them bodily harm or somebody else bodily harm, or if you believe that they could cause bodily harm if they were trying to defeat an arrest. Basically, if they were trying to not be arrested, you could use deadly force to stop them if you reasonably and necessarily thought that they could harm other people with a deadly weapon, and he did have a knife.
I think that is very compelling for a jury. Mike, do you agree with that?
I absolutely agree. Absolutely agree. Now, so
repeating there, let me just go back to that it's not it. If he is trying to defeat an arrest, if Laquan McDonald is trying to defeat and arrest a police officer, which means, they're asking him to stop and drop the knife. He's not doing it.
Right.
He's got the knife in his hand. He continues to move. I think a jury might reasonably decide that is an attempt to defeat the arrest. If that's an attempt to defeat the arrest, then the first shots are justified.
Right. Now, so Eric, did any witness testify today that to sort of contrast what the prosecution witness said when they called the former FBI agent about that it was justified, that the shooting was justified?
No, we're waiting for their use of force expert. We thought that he was actually going to be called today.
Mm-hmm.
But
the defense use of force.
The defense, yes.
So they have not called that person yet?
No, not yet.
Mm-hmm.
Because in order to prove guilty of murder, you would have to say that he acted with lawful justification of the use of force policy, right? Because that you acted outside the bounds of what a police officer is allowed to use.
And he acted with the intention of killing him. Yeah.
Mm-hmm.
So it's a pretty tough standard, but we've been saying all along, it's a tough prosecution standard to prove that Officer Van Dyke is guilty of murder. Mm-hmm. But we'll see.
Yeah.
And then the other charges here, we don't know actually what the jury is going to be instructed until this is all over.
Right. They're going to have a jury instruction conference soon, and they'll decide whether or not they'll be allowed to decide that he's guilty of something less than murder, like voluntary manslaughter.
Okay.
How does that work when I know the attorneys got together, but how do they decide that? Does the defense decide to ask the prosecution, we want the jury to consider other things, or does the prosecution say, we want the jury? How does that
Either side can offer it, either side can object, and the judge decides.
The surgeon also was there today. Do you think that was important and compelling testimony explaining that he died and likely would not have been able to survive that injury even if I had gotten to him immediately, seconds after those 1 or 2 shots that the defense is trying to prove were the deadly ones hit him?
Yeah, he said this was a surgeon that worked on him at Mount Sinai Hospital after he arrived with no pulse, as the doctor testified today. He said that the shot, the one that hit him in the chest, the one that hit his pulmonary artery, he would have been dead within 1 to 5 minutes. He said even if we had a surgical team standing right next to him and he was shot, his chance of survival would have been 1%.
And this is to sort of defeat the prosecution point that nobody went to his defense when he was shot, when he was on the ground.
I'm trying to say it wouldn't make a difference, the defense is saying.
That's what defense is saying, right?
All right. Leave right there for a second, gentlemen. Let's find out from Judy what's happening in the WGN newsroom at the bottom of the hour.
Kavanaugh's accuser took a lie detector.
Watch Micah and Joe, Micah Matera and Joe Donlin, weeknights on WGN TV News at 9.
All right, coming up on the program, Tom Skilling is going to join us. And then after 4 o'clock, the president is going to have a unilateral press conference in New York City. We will take you there live.
A lot of ground to cover, I'm sure.
Yes. Obviously, tomorrow he is meeting with Rod Rosenstein. Will he stay or will he go? And let us also not forget that the Kavanaugh accuser and Kavanaugh himself are going to be testifying up before the United States Senate.
That's right, the
in
Judiciary
Washington
Committee.
tomorrow. And others, there are two other accusers of a sort here. There's the one that we saw that was in New Yorker that Ronan Farrow wrote about.
Right. Yeah, Deborah Ramirez.
And then there's Michael Avenatti's client, who is a woman who says that her name is Julie Swetnick, and she says that she attended parties when she was in high school in which Kavanaugh was there and this Mike Judge guy was also there, and that they would intentionally drug or get women drunk so that they would not be able to defend themselves, and they would put them in a bedroom, and then boys would line up outside the bedroom.
Yeah, that's not good.
Yeah. So that's what she is claiming here.
We'll see what happens.
Now, there is a statement that has already been released to the Senate staff from the Judge Kavanaugh people, whether it's his attorneys or Kavanaugh himself. And they released a little outline of what he's going to talk about tomorrow, including his opening statement. And he will admit, according to that document, he will tacitly admit to not being always doing the right thing while in high school.
That may be smart to say something like that.
But I think in the questioning, they'll push him to understand what that means. Because I think all of us would admit to not doing the right thing necessarily in high school all the time. Right? I mean,
I'm not going to admit
would
that.
you admit that would be what you would have to say?
I would like to say something here. I had to, for
Your attorney
my other,
is right here on standby just in case.
For my other job, and Eric, I'm putting you through law school, so just in case Mike can't show up, you're gonna handle this.
Sounds good.
I had to go find my high school yearbook for work today for TV, and I pulled up my high school senior page.
Yep.
And I was
What'd you
looking at it,
find?
and there are things in those quips, those things that we saw him in. Now, what I was reminded of when I did that is that we didn't write those.
You didn't write them about yourself.
No, they were written by your classmates.
The editors.
The classmates.
My parents wrote mine.
What?
Yeah.
Your
Oh, such a
parents?
nice
Where did
boy.
you go?
Yeah.
Was it here in Chicago?
No, I grew up in Des Moines. I went to a nice Catholic high school.
We didn't even have those at Lane Tech. You didn't write like things next to your name. It was just your picture, and then you appeared in a photo of activities that you were part of.
Yeah.
We didn't have that.
We had small classes, so they had to fill the yearbook with something.
So we had 5,000 students.
Right, so it was a little different kind of a deal.
But
Kevin's mom, though, wrote all of his.
Don't write that! Don't tell anybody about that. Nobody's supposed to know. Kevin's pretending not to hear you right now. He knows not to wade into these waters.
Yeah. Anyway, the point is that I saw some things in there that I'm like, there were references in my yearbook that only people from that era would remember, but they're kind of about relationships.
And they're things you maybe wouldn't be proud of, or were they trying to embarrass you with those? Like you kind of maybe put some detail in there that would not necessarily even be true, or.
A counsel? How should I answer that question? I'm going to let my counsel answer.
I guess what I'm saying is I had no idea that others wrote those things for you. And when I read the Kavanaugh thing, I think that's a material question. Did he write that about himself and his own, the kegs, 100 kegs or die, and these other things, it's the acronyms that we're not sure what they mean, but they seem like some really bad things that could be attributed to. Did he write about himself, or were his buddies trying to sort of
that's what
embarrass
happens
him?
Is everybody write, they're written for, by your classmates about you. That's at least how we did it. And my guess is that's how that was too.
Well, and I would assume the law review, the review editors, the people who are...
The law review, no, it's a yearbook.
The yearbook
editors.
Review editors will have to have something to do with it.
And all I know is that I didn't do anything like that.
No.
I wasn't bad like that, but I was bad in other ways.
Yeah.
I did other things.
I don't think so.
No, I didn't. My lawyer just spoke. All right, thank you,
Did you hear
Michael.
him?
Thank you, Mike Monaco, attorney for Rocog. We've got Judy Prilak standing by. She's got WGN News coming your way right around this corner.